The following podcast contains opinion and commentary protected by the First Amendment and fair use. It may also contain adult themes, adult concepts, and adult language not suitable for children. Viewer discretion is advised. Welcome, ladies and gentlemen, back to your favorite cubbyhole on the internet. I am the said cub in the cubbyhole, and today is a grand day for a little stroll through the park, for a little jaunty music that very few might appreciate other than a friend of mine. To kick this thing off, it's almost clown music, isn't it? Or at least a charming player piano. But it is a grand day to discuss another milestone in the Laura Owens insanity case. Yes, it's insane because if anyone were to go any further with it, they really are insane. And maybe it might be certifiable. I'm not really sure. But here we are. This dropped yesterday. People are already talking about it because we've been waiting. And while I thought for sure we'd be waiting just a little while longer, we have this morsel of tender, steamy goodness just waiting to discuss. It's just so fresh that I'm beside myself. I heard just a quick reading through of the appeal of the appellate court's decision. I can't talk. I am so excited. I feel like like a little puppy dog, and I'll probably tinkle all over the place. This is just crazy. This should be where it stops. I should hope. I should think, because anything else is going to cost more. It's going to cost a fortune, and Clayton Echard certainly doesn't deserve that. And if we're being fair and honest, Laura Owens doesn't deserve it either, because I don't think David Gingras can keep affording to run this sham of a defense. Because, well, not even no one on the appellate court saw any of this as worthwhile. He lost. He lost big. He got bulldozed by 3 judges sitting in the appellate court. And so much so, I should think that one might want to consider a little bit of a career doing something else. Maybe doing landscaping. Or, I don't know, maybe flying drones or some other things. But he got his ass slapped. And quite a few times, because quite honestly...
A fucking douche canoe.
Yes, he's a fucking douche canoe. And he should learn from this. The appellate court was not playing around. They got down to brass tacks, and they called out everything. They called out absolutely every one of his antics. And they were so incensed by this, you might remember early on, that Dingus, the douche canoe,
The fucking douche canoe.
wanted to have oral arguments before the court. I don't know how often that happens. I really don't, nor do I care, but the court decided they weren't going to do that. They thought this was such a nonsensical farce that The immense amount of litigation and motion practice that happened in all this bullshit of
The fucking douche canoe.
Dingus the douche canoe. It wasn't worth wasting their time to hear any sort of oral arguments at all. That's how much of a slap in the ass this is. And it's absolutely juicy. Now, I should preface this that because I'm so excited by this. And I hope this is the end of the line for this case, because it needs to come to an end. Laura Owens has abused plenty of men. David Gingras has abused and threatened and done some horrific things to a number of other people, content creators, other businesses, and carrying out this bullshit, this scam, this sham of a vexatious litigation process. That all began with Laura Owens being rejected by men who saw that she wasn't what she claimed to be. That's the crux of this thing. This is all about a woman who cannot take rejection. And there's some theories for that. Some of them are mental health theories. Some of them are absolute entitlement theories. Some of those are based on horrific and terrible parenting by her parents. Because really, when we look at things, the apple never falls far from the tree, does it? Sometimes it does, but usually there's reasons for that. But in the case of Laura Owens, her mother's a conniving woman based on the footage we've seen from body cams and the not-so-effectual Scottsdale Police Department and all of those wellness checks that they were actually supposed to perform, and as far as we know, never did. It was an embarrassment. But that woman was so conniving and so in on this scam of Laura's, her own daughter. She's in a... Maybe she can see some collateral charges for aiding and abetting her daughter in this scam. Because really, she wasn't alone in these efforts. She was being helped, we assume, by family, because there were things that sounded like they could be her mother. We know that Laura made a number of different profiles to try and cover her tracks, including Chase J. Jones, a black journalism student. That's what they purported to be. But through the great detective work of Dave Neal, it was found to be that it was, in fact, Laura Owens pretending to be somebody else. So, we could even point to racist things that this woman will go to try and save her ass from getting prosecuted. And I really hope that the prosecutor in the Scottsdale and Phoenix area actually finishes this up and places some charges against Laura Owens. And I hope even further that her attorney, Dingus the douche canoe,
The fucking douche canoe.
is also on the receiving end from at least the Arizona bar, if maybe not the prosecutor's office as well. Because this kind of bullshit shouldn't be allowed to even enter a court. There should be maybe an investigatory hearing if it's really that necessary, when it's clear and apparent this woman has a pattern of behavior, of abuse, of abusing the court system, of vexatious litigation, of fake and fraudulent protective orders against other men who did nothing to her. There is no factual basis for any of these orders and claims of protection that she sought out and defrauded the court to get. This should come to an end. This should be the end. And we hope it is. So let's take a look at the actual document from the Arizona Court of Appeals, Division Number 2, with Laura Owens, the petitioner appellant, versus Clayton Echard, respondent appellee. And this was filed very recently. So fresh. Fresh like brownies right out of the oven. Delicious. Still tender and juicy and warm and gooey. Just the way I like them. You might like them a little bit more on the cold and crunchy side, but when it comes to things like this, I think the fresher the better. Yes, there's already people talking about it. That's great. I'd rather be right than first. And here is just the front cover page. We'll just skip ahead to the good stuff. Owens v. Echard, decision of the court. Memorandum decision. Judge Vasquez authored the decision of the court in which presiding Judge Ekstrom and Judge Sklar concurred. It sounds like it was a unanimous ruling. No dissension among the judges. A very clean ruling. I would say it's damn near impossible to take this any further. Now again, I have to preface that I'm not a psychologist. I am not a lawyer. I'm just another schmo, a cub in a cubbyhole, using his hole to talk about the insanity of other people in public. And boy, is there a lot of insanity in public to talk about these days. Vasquez, judge. In this paternity action, Laura Owens appeals the trial court's award of attorney's fees and costs in favor of Clayton Echard. She argues that Echard's failure to comply with the safe harbor requirements of Rule 26 precluded sua sponte sanctions under any authority and that the amount of fees awarded was unreasonable. She also argues that the court committed structural error by conducting its own post-trial investigation into the facts of the case. For the following reasons, we affirm. I almost think that seems like it should be a colon, doesn't it? We affirm the following. And I'll just reiterate. If you want a very flat, very professional reading, go see Schnitzel Ninja. She reads this very elegantly with no commentary, but I am going to rattle on like crazy because it's time for a little bit of a victory lap in this case. And this decision gives it to us. All right. Facts and procedural background. We view the facts in the light most favorable to sustaining the trial court's findings and orders. In May 2023, Owens and Echard had an intimate encounter. Shortly thereafter, Owens learned she was pregnant. In August 2023, she filed a paternity petition alleging Echard was the father. Echard denied paternity. And I'll also interject that I may not read all of the rigmarole case law and the stuff. It's there on the screen. If you want to dig it up, you're more than welcome to. Schnitzel does a schnitzel. Schnitzel or schnitzel? I'm going to go with schnitzel because that just sounds more authentically German to me. She reads all of this stuff and does even quotes. We'll just cover the highlights here and maybe some of the the lowlights. Oh, the smacking down that is to come. Oh my God, I'm so excited. In December 2023, the case was placed on the administrative dismissal calendar for lack of prosecution. Echard moved to extend the dismissal date, arguing that he was entitled to an adjudication finding of non-paternity, which he was. He also requested an evidentiary hearing on the paternity issue, attorney fees, and Rule 26 sanctions. In response, Owens informed the trial court she was no longer pregnant, and thus there was nothing left to adjudicate, and this case should be dismissed. She simultaneously moved to dismiss the case with prejudice. Echard opposed. Echard then separately moved for Rule 26 sanctions, arguing Owens' petition was filed for an improper purpose. Her motion to dismiss was unsupported by existing law, and her factual contentions were not supported by evidence and did not become supported by evidence after investigation and discovery. Owens responded that Echard had not complied with Rule 26's requirements because he did not provide her with written notice of specific conduct alleged to have violated Rule 26, and that she was, therefore, not afforded time to cure any alleged deficiencies. Echard eventually moved to withdraw his Rule 26 motion, arguing that there was no reason to participate in the pointless litigation over this issue, notwithstanding his disagreement with Owens' legal positions on Rule 26, because Rule 26 was not the substantive pleading basis for his claims for attorney fees and sanctions. The court extended the dismissal deadline, denied Owens' motion to dismiss, and set an evidentiary hearing on the issue of sanctions and attorney fees. After the evidentiary hearing in June 2024, the trial court granted Echard's request for attorney fees and costs. In July, Owens filed a notice of change of judge for cause under Rule such and such, arguing the judge was biased and had engaged in conduct that violated her right to due process. The presiding judge denied her motion, concluding Owens had failed to prove, by a preponderance of the evidence, that the judge was biased or prejudiced. Also in July, Owens moved for relief from the judgment or, alternatively, to alter or amend the judgment, which the court ultimately denied. In August, the court awarded Echard attorney fees and costs in the amount of $219,076. this appeal followed. We have jurisdiction under that case law. Footnote 1. The trial court's August 2024 judgment was not certified as final under the applicable rules, and the June 2024 ruling was improperly certified as appealable under Rule 78. We therefore suspended the appeal and revested jurisdiction with the trial court to allow it to enter a final appealable order. After that, court amended the August 2024 judgment to include the requisite finality language under Rule 78. We vacated the stay and revested jurisdiction in this court. Owens argues that because Echard did not comply with Rule 26's safe harbor requirements, she was shielded from any punishment arising from her alleged violation of Rule 26. Footnote 2. Rule 26b provides that by signing a court filing, a party is, among other things, certifying that it is not being filed for an improper purpose, the claims are supported by existing law and are non-frivolous, and the factual contentions have evidentiary support. If a party violates the rule, the trial court may impose sanctions, including reasonable attorney fees. However, before seeking sanctions under the bottom of the page rule, the moving party must attempt to resolve the matter by consultation. As a preliminary matter, we note that a significant portion of Owens' appellate argument relies on her incorrect assertion that the trial court ordered sanctions under Rule 26. The court expressly awarded attorney fees and costs under that case law. We thus declined to consider whether an award under Rule 26 would have been proper. We review the trial court's decision to award attorney fees and sanctions under that law for an abuse of discretion. But we review a court's interpretation and application of statutes de novo. Owens argues that because the hearing was set in response to Echard's Rule 26 motion, and because he did not file any other motion for fees or sanctions, of course the court sanctioned her under Rule 26, relying on Rule 35, Owens contends a fee or sanctions request must be made by separate motion. While this is true for Rule 26 sanctions, the same is not true for attorney fees requests under that case law, or sanctions for litigation misconduct under other case law. Court can impose discovery sanctions under its own inherent contempt power. 9. Nevertheless, Echard properly requested attorney fees and costs under those authorities throughout the litigation. For example, he requested attorney fees and costs under 25-324 based on Owens' unreasonableness in his motion to extend the dismissal date on the inactive calendar and schedule an evidentiary hearing, which was filed before Owens moved to dismiss the case. Echard made the same request under 25-324 in his reply, as well as in amended response to the paternity petition. Moreover, in Echard's motion to withdraw his Rule 26 motion, he argued that he was entitled to attorney fees and costs under ARS so forth, and that his claims for fees and sanctions exist independently of Rule 26. We'll get to those footnotes in just a moment. These requests were also repeated with supporting arguments in his pretrial statement. So footnote 3, which happened a little bit earlier. In its ruling, the trial court ruminated about whether it could sua sponte award sanctions under Rule 26 after party moves and then withdraws a motion for Rule 26 sanctions. Presumably, it did so because this question was heavily litigated by the parties below. Ultimately, however, the court did not award Rule 26 sanctions. And footnote 4. Echard repeated this argument in his response to Owens' combined motion for judgment on the pleadings and his renewed motion to dismiss. The trial court found Owens' motion to be moot and declined to take further action. However, there was a delay in the parties' receipt of the court's ruling, and the court found this motion was filed with the belief the court had not accepted Echard's motion to withdraw. 10. Owens argues the trial court lacked the authority to impose attorney fees and sanctions independently from Rule 26 because Echard filed and subsequently withdrew the Rule 26 motions. She maintains that Rule 26 must control and must provide the exclusive remedy for conduct that would fall under a Rule 26 violation. In support of this argument, she relies on the proposition that when two rules deal with the same subject, the more specific rule controls. But the statutes under which the court granted attorney fees did not govern the same subject matter as Rule 26. Section 25-324 governs attorney fees, not sanctions. And the sanctions for costs and attorney fees that the court ordered under 25-415 were based on Owens knowingly presenting a false claim and knowingly violating a court order compelling disclosure or discovery, which is distinct from conduct that would constitute a Rule 26 violation. We decline to hastily find a clash between a statute and court rule, especially when the statute and rule govern different subjects. 11. Owens next argues that the attorney fees and costs awarded under 25-324 and 25-415 were improper because they were neither necessary nor reasonable. She asserts Echard's fees were literally $0 prior to November 2023, and if his counsel had simply picked up the phone in mid-December and asked her about her intentions, she would have informed him that she was no longer pregnant, and there was nothing further to litigate. She similarly argues that Echard's decision to file the Rule 26 motion was the precipitating factor in incurring fees. She contends that if Echard had done nothing, the case would have been administratively dismissed, without a single dollar of fees incurred by either side. Therefore, she maintains that even if her petition were unreasonable, it was not the filing itself that caused fees to be incurred, but rather Echard's choice to pursue sanctions. But that administrative dismissal would have been without prejudice, so it would not have precluded Owens from initiating a future paternity action, nor would that dismissal have been equivalent to the order Echard sought and ultimately obtained, that he was not the father in connection with the alleged pregnancy. At any rate, none of these scenarios posited by Owens have any bearing on the propriety of the fees awarded in this case, as that determination must be based not on conjecture, but on what actually occurred. At the time of Echard's request for an evidentiary hearing on the paternity issue, attorney fees, and Rule 26 sanctions, Owens had not informed him that she was going to move to dismiss the case. And in her response to Echard's request filed simultaneously with her motion to dismiss, she acknowledged that the only remaining issue was Echard's request for attorney's fees. Echard objected to Owens' motion to dismiss, arguing her avowal that she was no longer pregnant was insufficient to grant a dismissal. He also requested an adjudication that she was never pregnant, or, at least, that she was never pregnant by him, and an evidentiary hearing on his attorney fees request. The trial court ultimately granted Echard's motion to extend the dismissal deadline, stating the issue of sanctions and attorney's fees remain. Owens does not challenge this ruling on appeal, and the fact that the parties incurred attorney fees because they heavily litigated these issues was within the court's discretion to consider, and not something this court will reweigh. 13. Here, the trial court found Owens had acted unreasonably in the litigation by filing the case without basis or merit. Court may award attorney fees after considering, in part, the reasonableness of the positions each party has taken throughout the proceedings. An applicant need not show both a financial disparity and an unreasonable opponent in order to qualify for consideration for award. The court also found it disingenuous at best, but certainly misleading to the court, that Owens had testified the purpose of her motion seeking mediation was to inform Echard the pregnancy was not viable. It further found she had failed to comply with disclosure requirements, which caused Echard to incur substantial legal fees attempting to locate records that may or may not have existed. Now we remember, because this jumps into my head, and I'm going to interject as I'm wont to do, in her testimony in the June hearing, she said she changed her story after her deposition. And she changed her story on the stand. As you might recall, she stated that she had anonymously gone to Planned Parenthood in Mission Viejo. And then at trial, she said no, it wasn't. She had gone anonymously or by some presumed name that she wouldn't disclose in Los Angeles. Of course, we know that none of the above happened, and this was just more of her bullshit. It was all of the Laura Owens sleight of hand. The court also concluded that 25-324 applied because Owens had provided false testimony as to the viability of the pregnancy and had sent Echard a letter prior to her deposition that indicated her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. Oh, I've got shivers down my spine. The appeals court sees through all of it. Isn't this marvelous, folks? Number 14, on appeal. Owens does not meaningfully challenge these findings, but instead argues 25-324 does not apply in paternity actions. That section permits a court to order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any proceeding under Chapter 3 or 4, Article 1 of this title. Chapter 3 governs dissolution of marriage, and relevant here, Chapter 4, Article 1 governs legal decision-making and parenting time. Owens argues that paternity actions are, by definition, excluded. I need a buzzer. I need a buzzer button. You're wrong. A family court's authority to conduct legal decision-making and parenting time proceedings is provided by ARS 25-402. Under that statute, a parent is required to request such a determination in any proceeding for marital dissolution, legal separation, annulment, paternity, or modification of an earlier decree or judgment. See that case law. Here, Owens petitioned the trial court for orders concerning paternity, legal decision-making, parenting time, and child support. Remember when she said, ladies and gentlemen of assorted beasts, that this wasn't about the money for her. Do you remember that? It was. Oh, and another thought. I remember when, True Crime, Lauren Conlon and Jack in her episode, where we looked at some of the things in Jack what's the name of his channel? I've forgotten all of a sudden. I'm so excited. I'm so excited. I'm forgetful. He did that analysis on some of the writings and said, "Oh, this is definitely about the money. Among other things, it's about her moment of fame, and it's about money and a few other things. Oh, it's about so many things." While the court ultimately did not issue legal decision-making and parenting time orders, Echard defended any proceeding under Chapter 4, Article 1 of this title by virtue of Owens' petition, as was reflected in his amended response. 15. Even assuming the trial court's fee award was improper under 25-324, because of this case's procedural posture, the court's findings would have supported a fee award under 25-809. We may affirm trial court if legally correct for any reason. Echard cited 25-809 in seeking attorney fees, so the issue was also properly before the court. The language in 25-809 largely mirrors that in 25-324 and permits a court to order a party to pay a reasonable amount to the other party for the costs and expenses of maintaining or defending any paternity proceeding. We reject Owens' suggestion that this paternity action somehow transformed into some other type of proceeding because the parties only incurred fees after it was scheduled for administrative dismissal without prejudice. The court did not err in awarding attorney fees. The court did not err in awarding attorney fees. Number 16. The trial court also properly awarded fees and costs as a sanction under 25-415. The court found that fees under the statute were appropriate because Owens had knowingly violated a court order compelling disclosure or discovery. Knowingly violated.
But Your Honor, I should be entitled to get away with anything.
No, Laura, you can't. Oh, Owens argues she fully complied with the court's disclosure order as was demonstrated by the fact Echard never brought any motion seeking sanctions under 24-415. She argues because no motion had been filed, she did not have the opportunity to prove she fully complied with the court's order. Although 24-415 does not require the filing of a separate motion as previously noted, Echard requested relief under this statute. Section 24-415 states that the court shall sanction a litigant for costs and reasonable attorney fees incurred by an adverse party if the court finds that the litigant violated a court order compelling disclosure or discovery. Here the court made such a finding. Owens does not meaningfully challenge that finding. Again, the court did not err in awarding Echard his costs and reasonable attorney fees. The court did not err in awarding Echard his costs and reasonable attorney fees. On appeal, Owens also claims that the amount of the fee award was unreasonable. The substance of her argument is that below she had noted the amount of fees was patently unreasonable in light of the controlling standard of Ethical Rule 1.5. But because she fails to identify with any particularity what evidence supports her argument, we conclude that the court did not abuse its discretion in fixing the amount of attorney fees it awarded. Part the second. Denial of motion for relief from judgment. Paragraph 18. Owens argues that the trial court erred by denying her motion for relief from judgment or, alternatively, to alter or amend the judgment. We review the denial of such motions for an abuse of discretion. Because Owens does not argue how the court erred in denying her motion, but instead asserts that the only available remedy is automatic reversal, because the misconduct is per se structural error of the most obvious kind. We do not address the court's denial of her motion. Let's see, interjecting footnote 5, which happens up above. Let's see, there's exceptions in section 25-415. If the court finds that the failure to obey the order was substantially justified or that other circumstances make an award of expenses unjust, it is not required to impose sanctions. The court made no such findings here. Absolutely so. Section 3, judicial bias. Owens argues that the trial court improperly performed an independent and undisclosed investigation into the facts of this case, and from this investigation made post-trial findings, not based on the evidence submitted at trial. In the findings of facts section of its ruling, the court stated that Echard's expert had testified that Planned Parenthood is not open on Sundays. When Owens testified, she sought care July 2nd, 2023, a Sunday. The parties agree the expert did not testify that Planned Parenthood is closed on Sundays and that the court's finding was therefore erroneous. Instead, they dispute which standard of review should apply. Owens argues this amounted to structural error requiring automatic reversal because it proves the trial judge was biased and shown by the judge's decision to engage in unlawful conduct which violated her right to due process. Conversely, Echard argues that the controlling standard for alleged mistakes in family law proceedings is harmless error. Structural error is generally applied in criminal cases and is error that affects the framework within which the trial proceeds, rather than simply an error in the trial process itself. The Supreme Court has defined relatively few instances in which we should regard error as structural. But one of those instances is a biased trial judge. We nevertheless decline to apply a structural error analysis given the record before us. Denied. Sit down. Here, Owens moved for a change of judge for cause under Rule 6.1, Arizona Family Law, on the basis of bias and prejudice within the meaning of ARS 12-49, etc. The presiding judge denied her motion, while acknowledging that the trial judge's finding about Planned Parenthood's business hours was clearly erroneous. The presiding judge concluded that Owens had failed to show by a preponderance of the evidence that this finding reflected bias or prejudice against her. Owens contends that we need not separately decide whether the presiding judge erred when she denied Owens' notice of change of judge for cause, because the requested relief is subsumed within the structural error arguments that we must review de novo. But as we explained below, the record does not show that the trial judge was biased. Thus, even assuming without deciding that structural error applies in family cases, it did not occur, and the presiding judge did not abuse her discretion in denying Owens' motion for change of judge for cause. We review for an abuse of discretion the denial of a motion for change of judge based on a claim of judicial bias. 22. Owens argues that the trial court's erroneous finding of fact demonstrated it was biased and therefore committed structural error. Her argument is biased on conjecture. She does not provide any evidence showing actual bias. Her claim of bias is based on her assertion that the court intentionally tried to conceal its misconduct in performing its own post-trial investigation into the facts by falsely attributing the testimony to Echard's expert. Owens claims this is the only plausible conclusion, given that the online supporters of Echard had vociferously posted about this issue online hours after the trial ended. These unsupported and speculative allegations fail to meet her burden to prove bias by a preponderance of the evidence. Owens further contends that any independent factual investigation by a trial judge is unlawful and shows bias. But for structural error review to apply, the type of judicial bias that must be shown is that which implicates a party's due process rights, such as bias based on a direct personal substantial pecuniary interest. None of those grounds apply here. We therefore review for an abuse of discretion. The following case law there. While a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias apart from any structural error claim, the critical inquiry that would require reversal is whether the conduct demonstrates an extrajudicial source of bias or deep-seated favoritism. Owens correctly notes that the court misstated trial testimony, but she is incorrect in asserting that because harmless error analysis does not apply, she does not need to make a separate showing of resulting prejudice. Prejudice will not be presumed, but must be evidenced from the record. There must be evidence, ladies and gentlemen, and assorted peoples. Further there, within the case law, unless justice requires an otherwise an error by the court or a party, is not grounds for disturbing a judgment or order. Therefore, even if the court conducted independent research under a prejudice analysis, we would still have to determine whether Planned Parenthood's business hours were vitally important to the court's ultimate conclusions, as Owens claims. However, Owens does not argue prejudice. Consequently, the presiding judge did not err in denying Owens' motion for change of judge for cause. The presiding judge did not err in denying Owens' motion. The record does not show judicial bias, and Owens does not challenge any of the presiding judge's rulings under the appropriate standard for appellate review. Section 4, Attorney Fees on Appeal. Owens and Echard request their attorney fees and costs on appeal under 25-809. Echard additionally requests fees and costs under 25-324. Under both statute, the court may award attorney fees and costs after considering the financial resources of both parties and the reasonableness of the positions each party has taken throughout the proceedings. While the record does not support a disparity in the parties' financial resources, Owens' position on appeal is unreasonable. Owens' position on appeal is unreasonable. Her Rule 26 argument is not grounded in law or fact. Likewise, her assertion that the trial judge was biased and committed structural error does not meaningfully address the trial court's rulings below and also ignores the applicable jurisprudence. We therefore award Echard his reasonable attorney fees and costs on appeal upon his compliance with Rule 21, etc. For the foregoing reasons, we affirm the trial court's judgment. Dingus the douche canoe has lost again, and Laura Owens loses her appeal. And that's all because Dingus the douche canoe.
The fucking douche canoe.
And that just seems to be a statement of fact as far as the appeal goes. There we are, folks. Laura Owens has lost yet again. The unsinkable Titanic of Dingus the douche canoe.
The fucking douche canoe.
Is taking on water so fast. They might both be in trouble. It's an amazing thing, isn't it? When the judicial process works, it's an amazing thing. And I wholeheartedly think the process has worked as it's supposed to. Dingus the douche canoe manufactured a bunch of bullshit. He inflicted as much damage on other people not related to the case at all, as much as Laura did to all the people she has abused and all the people she continues to abuse through her fraudulent filings and through her fraudulent protective orders. But as I said in the beginning, it's time for this charade to come to an end. Laura Owens should be prosecuted for her criminal conduct in all of these matters and all of her preceding matters. When that criminal trial takes place, all of the men she has harmed repeatedly should seek to have all of their orders of protection against them vacated, because Laura Owens should be charged with crimes. I think that goes beyond just a statement of opinion. According to the statements of the appeals court, as I understand them, they affirmed that Laura Owens committed perjury, essentially. She lied on the stand. She altered her testimony from her deposition. There was nothing reasonable in any of her claims of pregnancy with any of the men so far. There may be something that we can't quite prove that might have happened in the past, but there was no evidence of pregnancy. There were lots of claims of various sorts of abortive things. I think most, if not all, were manufactured. They were manufactured by Laura Owens to abuse. They were manufactured by Laura Owens to use abusive processes via the court system to perpetuate her delusional, psychotic being. Her psychotic being of just being a terrible person that can't take rejection from men who may have been interested in her, but then discovered that she's a flawed woman. I don't think she's flawed beyond repair necessarily, but I believe the way she was brought up by her terrible parents, who were probably egomaniacal narcissists. I mean, when you have two people who are in front of the microphone for their careers, they're probably slightly narcissistic, if not entirely narcissistic. Again, we saw the behavior of Jan Black Elizabeth Naylor Owens, I think is the majority of her aliases. There may be others for all I know. Like daughter, like mother, like daughter. I still have a theory that maybe Jan Black might have used this tactic to rein in Ron Owens. I don't know that. I don't have any factual basis for that. It's just a hunch. Because where else would Laura Owens have learned this little technique of, I'm going to date guys, I'm going to pretend I'm pregnant, and then to kind of perpetuate this nonsense, this fantasy of fiction, this pregnancy fiction, this pregnancy twin pregnancy fiction, for Christ's sake. I'm going to take them to court and say, well, I was pregnant by you, and start. This is all about vexatious litigation and Laura Owens wanting to be abusive, and it needs to stop. And I duly hope the prosecutor's office in Arizona we'll take this to the next step. And we will next see a criminal trial for Laura Owens. I don't know who she would get to represent her in such a trial. I don't think it should be David S. Gingras Esquire.
The fucking douche canoe.
Because he has absolutely failed at every turn to keep her out of the hot seat. And when he has only engaged in other vexatious litigation tactics himself to keep people from discussing this so that he can bury it, sweep it under the rug. And evil people like Laura Owens can continue to be abusive. That's what David Gingras Esquire,
The fucking douche canoe.
argued from the very beginning. He argued that she should have the right to just escape this without consequence, that it should be essentially freedom of speech was his first argument, as I recall. And that's utter shit. Or utter shite, as our friends across the pond might say. It's a load of bollocks. And there's nothing but a bunch of cuntiness going on if this case, were to go any further, but die a very quick death in the Court of Appeals. And this is where it should stay. This is where it should remain. And I hope it stops here. Because if it doesn't, we'll just have more to talk about. We'll have more to mock about this sham, this scam, this fraud. That is the pregnancy sagas of Laura Owens. Be they single pregnancies, be they twin pregnancies. They're all non-existent pregnancies to date. So really what difference does it make? But this should conclude. And if I don't stop rambling, I should conclude myself before. Oh my goodness. I'm sure the others, maybe they'll take a break from their Hales cases and other things that they're looking at, the whole Baldoni things. I think Dave Neal is overdue for this. He may be doing something right now while I'm recording this, for all I know. I'm sure there will be an update by all the major league hitters in this who have discussed this case in the past, and lovely to them. I will enjoy listening to every minute of it. And hopefully they come to the same conclusions I do. I think they will. I think we're all of the same mind. In the cult, as David S. Gingras Esquire, the douche canoe would call it.
The fucking douche canoe.
If we are a cult, I think we all agree that it's time. It's time to let this sail off into the sunset, pay Clayton Echard his pile of money, and be done with it. And strongly suggest that woman see one hell of a good therapist and psychologist and actually fix what's wrong with her, if that's even possible. I hope it is. I think it might be. Again, I'm not a mental health expert, but it's time. It's time for this to end, and it should end. Until next time, people, behave yourselves. Do good in the world. Use your freedom of speech to not let the injustices of the world hold us down. Don't let them steal people off the streets for non-disclosed immigration things. Okay, I'm getting political now. I probably shouldn't do that. But there's craziness in the world. We can all see that, right? Some of it, certain people brought it on themselves. But in the case of Laura Owens, it's time for this to end. And I hope this gives all the other men that she has wronged an opportunity to come forward, to share their stories, to share how she has harmed them and how she has injured them and how she has abused them, and to shine a final searing, sun-quenched spotlight on this whole thing. And with that, peoples, until next time.